His name was Prince. His legacy planning was funky, but only in the bad sense. He had no will and no estate plan of any kind. His IP portfolio, his music catalog, his publishing rights, his trademark on his name and on the symbol he used as his name for a while, his master recordings, his unreleased material, was worth hundreds of millions of dollars. Because there was no plan, his heirs, siblings, and half-siblings who had varying relationships with him and his music fought over who was entitled to what. The people actually managing the estate had to make decisions about licensing his music, about what would get released and when, about who could use his name and image, all while under court supervision, all without any guidance from Prince himself about what he would have wanted. Every decision became a negotiation. Now, you don't have to be Prince to need a plan, and I'm really sorry about that, but I kind of had to. Anyway, the IP succession planning mechanism is exactly the same at every scale. What jeopardizes the IP is not the volume of the assets, it's the absence of instructions. Imagine a founder, a woman in her early 50s who has spent 15 years building a product-based business. She has a registered trademark on her brand name, a utility patent on her core product, and copyrighted marketing materials and a few trade secrets baked into her manufacturing process. She registered the trademark in her own name years ago, and she licenses it to her LLC, which she runs with a business partner. She dies unexpectedly. No will, no business succession plan, an operating agreement from 8 years ago that nobody has looked at since it was signed and that does not say anything specific about what happens when a member dies. Her husband inherits her personal estate, including the trademark. He knows roughly what the business does, but has never been involved in running it. He doesn't know that the trademark renewal filing is coming due in 7 months. He doesn't know that the patent has a maintenance fee due next year. The trademark is now in the hands of someone who can't run the business, and the LLC is in the hands of someone who doesn't know how to protect the brand or the core product. Nobody wanted this outcome. Nobody did anything malicious. Nobody even did anything wrong except that nobody planned. Everything starts to unravel, not because the law failed anyone, but because nobody left instructions. I'm Julie King with King Patent Law. Avoid the legal horrors and keep rocking your IP. This is not legal advice and I'm not your lawyer. For advice about your specific situation, consult with a licensed attorney. This contains attorney advertising material. Firm address and contact information are available at kingpatentlaw.com.